Hello, everyone. This is Lauren Remus, formerly of America's Job Exchange, now part of CIRCA. Thank you for joining us today for managing a VEVRAA Focused Review. Before we get started, I do have a few notes. Please use the Q&A feature to submit your questions. We'll plan to address questions at the end of today's presentation as time permits. If we are unable to get to your question today, we will get back to you via email. Just allow a few days for that answer to come through. Thank you. After this event, a short survey will pop up. If you could take a minute to let us know what you thought of today's presentation, we always appreciate it. And now I'd like to introduce today's fantastic presenter, joining us from Biddle Consulting Group and BCGI. Please welcome Matt Nussbaum. Matt, thanks for being here, and I'll turn things over to you.
Thank you so much. I am so happy to be here. Today, we want to talk about managing an OFCCP VEVRAA Focused Review. For those of you who are not as familiar with the alphabet soup that is the federal government, VEVRAA stands for the Vietnam-Era Veterans Readjustment Assistance Act of 1974? I think so. I should probably know that. Anyway, the OFCCP has been telling us for a while, and in fact, they published an entire CSAL list for VEVRAA Focused Reviews, that focused reviews are the bee's knees. It's where the current administration is really focusing a lot of their efforts. It started with Section 503 focused reviews for your AAPs with individuals with disabilities, and they are now ready to dive in on VEVRAA Focused Reviews. And we want to help you close those focused reviews fast by being well prepared. So that is the impetus for today's presentation. And for those of you who don't know, who the heck is this guy? As she said, my name is Matt Nussbaum. I am the director of something that we call BCGI. That stands for the Biddle Consulting Group's Institute for Workforce Development, which is the education and training arm of the Biddle Consulting Group, and also why we call it BCGI for short. It's quite a mouthful. The Biddle Consulting Group has been, among other things, preparing and defending AAPs for nearly 50 years, basically as long as I've been alive. And I came to BCGI a little over a year ago, and in a prior life, I was an attorney. I'm going to ask you not to hold that against me. I guess I'm still an attorney. I'm just not practicing. I practiced in New York and Washington, D.C. for 10 years. Before that, I was a data analyst and computer programmer who specialized in database design, implementation, and management, and am intimately familiar with just how bad your business data is. And prior to that, I was a plumber, and I'm proud to say that I've still to this day never met a toilet that I couldn't fix. That doesn't really have anything to do with anything, but just to give you a sense of who it is that's yapping at you right now. But let's go ahead and dive right in with the sort of requisite background. For those of you who are well steeped in this, go ahead and play some Sudoku, but keep an ear out for when you need to jump back in. For the rest of you though, just a quick who's who and what's what, right? A lot of this really began in earnest with Title VII, 1964, 56 years ago. Congress enacted the Civil Rights Act outlawing discrimination in the workplace on the basis of race, color, religion, sex, national origin. We call those protected characteristics, right? And we're prohibited from using those protected characteristics as factors when making any type of employment decision, which includes a lot of things. Obviously, hires, promotions, terminations, and compensation are kind of the big four that the OFCCP and the Department of Labor understand that every employer engages in and are largely the focus of the vast majority of claims. But it could be anything from choosing people for training, management track, even inclusion in company-sponsored events. And so, sort of any decision that the employer makes that could affect someone's career is an employment decision, and we're prohibited from using those protected characteristics. I think most people are fairly familiar these days with the way that works. Title VII goes both ways with regard to race, ethnicity, and sex, right? It doesn't protect women. It doesn't just protect people of color. It protects people on the basis of their sex or on the basis of their race, ethnicity. It's enforced primarily by the EEOC. You can also be sued by a private plaintiff's attorney, but you have to go through the EEOC before filing a private lawsuit. And and exhaust your potential administrative remedies. The next year, President Lyndon Johnson attached some strings to accepting federal tax dollars, right? This is a scheme that, again, is, should be familiar to most. It's been something that the federal government is well practiced in. For those of you who are old enough to remember when most state highways set their speed limit at 55, and Sammy Hagar belted out that anthem in opposition because he just can't drive 55. The reason that the speed limit was 55 is because the federal government said, if you want federal tax dollars to help maintain your roads, you need to set your speed limits at 55. And so most states did, except for I think maybe Montana, and hilarity ensued. So this is a common thing that the federal government knows, that the purse strings can be a very powerful motivator. And so President Johnson decided to go a little bit beyond Title VII, which just says don't do it, and said, yeah, but how do you know? How do you know that despite your carefully worded policies and procedures and everything, that people still aren't engaging in practices that either intentionally or unintentionally are holding people back? And so for federal contractors, we're also going to require something called affirmative action, which has gotten a bit of a bad rap because the only form of affirmative action that tends to get coverage in the news is what I refer to as corrective affirmative action, things like quotas and point systems and set-asides that are extremely limited by the Supreme Court and are meant to be a last-ditch measure when literally nothing else will work to get the needle unstuck and allow it to move to where it needs to be. And they're temporary. They represent a very small portion of what affirmative action really is. The day-to-day grunt work of affirmative action means just actively making sure that the playing field is even and keeping it that way. In other words, the goal of affirmative action is to not need things like quotas and point systems and set-asides. And so this was all kind of introduced to the world in earnest in 1965, and the Office of Federal Contract Compliance Programs, the OFCCP within the Department of Labor, is the agency that is tasked with enforcement there. Employees can file a complaint with the OFCCP, but they rarely do. And of course, the OFCCP regularly audits contractors to ensure compliance, which is why most of us are here today. So the EEOC, the OFCCP, ABC, XYZ, this is the federal agency alphabet soup. The EEOC is the Equal Employment Opportunity Commission. They're an independent federal agency that, among other things, enforces Title VII of the Civil Rights Act of 1964 and the ADA and a few others. Their investigatory scope and authority is relatively limited, though. It's like an episode of Law and Order, where the cops can't come in and search the apartment without a warrant. And when they do, they are limited to searching for things in that warrant. On the flip side of the coin, though, for federal contractors, the OFCCP, an agency within the Department of Labor, has broad investigatory scope and authority. Basically, once they audit you, they have access to any document, data, or information that would be relevant to equal employment opportunity and affirmative action obligations, which is most of the business records that you keep. There's the selection process for audit is not technically random, but it must be administratively neutral. Generally, they can't target a contractor. But they can target an industry in a geographic region. And so if you're the 800-pound gorilla in that region, you may feel targeted, but they're not constitutionally allowed to do that unless they actually have cause or something like that. But they are a very active investigatory agency. And just like any other federal agency, they need to be able to show their receipts to Congress and justify their funding. And so they have all kinds of motivations beyond just wanting to protect the rights of employees and applicants. I put just in air quotes there. They have plenty of motivation, though, to be taking a look under your hood, rifling through your underwear drawer and seeing what they can find, and they do. Now, the EEOC and the OFCCP have similar jurisdiction, obviously, but different authority and methods. Like I said, the EEOC investigations are limited to the scope of the complaint. OFCCP investigations are almost unlimited. They're more like an FBI raid with a warrant to seize everything. And just in case, the EEOC and the OFCCP have something called a Memorandum of Understanding, an MOU, so that they can share information across agencies, and they'll sometimes perform joint investigations, kind of like the Wonder Twins. They join powers and bring the investigatory scope of the OFCCP into the investigatory experience and expertise of EEOC attorneys, and then things can get really interesting. Potential remedies, what happens when things go wrong? Well, neither Title VII nor OFCCP's regulations include fines or jail time for violations. Enforcement is primarily remedial, right? They try to put victims of discrimination in the position they would have been in absent the alleged discriminatory acts. In other words, if you hadn't run into this artificial barrier, where would you be today? And we try to put them there. That often involves compensation for losses due to violations. The OFCCP can also technically have contract payments withheld, have contracts canceled, or even debar contractors for a period of time, which prevents them from entering into further federal contracts. In reality, that usually doesn't happen without the contractor's consent. And the OFCCP can't really do that unilaterally. If you have a contract with, say, the Department of Defense, and the OFCCP wants them to withhold contract payments, well, they need to get DoD on board with that. And so it's a very complicated process reserved for very extreme circumstances that anyone on this call is unlikely to face. The main thing, though, is the public and employee relations issues to consider. That whenever an organization is accused of wrongdoing, especially using the dirty word of discrimination, the OFCCP and the EEOC are fond of press releases, letting people know what a good job they're doing. And in doing so, they can drag the company's name through the mud. And that can make, that can have all kinds of consequences and can absolutely have an effect on employee morale. And so for a lot of reasons, we want to make sure that we're compliant with Title VII, the ADA, USERRA, VEVRAA, all of our compliance functions. It's more than just checking a technical compliance box. The reason for doing these things is making sure that we're not damaging the company's reputation. And, oh, by the way, there are real people involved here who are affected when we fall down on this, affected in a negative way. And what it affects in particular is their ability to earn a living and provide for themselves and their families. So I tend to think that it's fairly important, and I'm glad that you're here joining me today. There are different types of OFCCP audits. They do, in fact, come in different flavors. So let's take a quick look at those. There is the compliance review. That's sort of the default. We usually refer to that as just an audit or a full audit. And that is a soup to nuts, taking a look at your AAP for women and people of color, your AAP for individuals with disabilities, and if necessary, your VEVRAA AAP for protected veterans. There's also a compliance check. That's sort of an audit light, where really the OFCCP is only looking at, can you comply? Do you have the systems and processes and procedures and record keeping in place to allow for compliance? That we don't see a lot of compliance checks. The OFCCP has revived them a little bit lately, but that didn't seem to garner a whole lot of excitement within the organization, within the agency, so we don't see them very often. When we do see them, it's usually in the context of a pre-award compliance evaluation, which is a compliance check prior to awarding a really big contract. But those are discretionary. The OFCCP can decline to engage in them. So we don't see them very often either, because just like everyone else, they're busy with all of these other types of audits. Particularly the one that keeps most people up at night is the Corporate Management Compliance Evaluation. That's the CMCE for short. It's a full audit with an additional focus on upper management and potential glass ceiling issues, sometimes referred to as a headquarters audit. Not all audits of headquarter locations are necessarily CMCEs, but most are going to be. And that's really kind of the fullest proctology exam on the menu. And then we have what we're here to talk about today, which is a focused review, which is somewhere between a compliance review and a full audit and a compliance check, where the OFCCP, instead of looking at all 2 or 3 of your AAPs. They're going to focus on and concentrate on discrete issues and take a deeper dive rather than a broader approach. So in general, the audit experience starts with the receipt of a scheduling letter. You actually get a physical letter in the mail from the Department of Labor. And so you don't want to ignore something with the Department of Labor's seal on it because they send it registered mail. Someone has to sign for it and a clock starts. As soon as someone starts, you have 30 calendar days to put together what's called the desk audit submission. The scheduling letter will ask for a bunch of data and documents and information, and they want it in 30 days from the receipt of the scheduling letter. Audits often, pretty much always, then involve follow-up requests for additional documents and data and information after the initial review of what you sent in for the desk audit. It may involve an on-site visit to include a facility inspection and maybe interviews of managers and supervisors and employees. Audits can, in fact, go on for years, although I have to begrudgingly give the OFCCP some credit here. In the last several years, they have made a Herculean effort to cut down the time that we spend in audits to give some of that time back to contractors so that they can focus their time and resources on their actual affirmative action obligations and initiatives and get to resolution and not get in the way. If substantive violations are found, then the audit typically ends with a conciliation agreement. This is a direct contract with the OFCCP to take specified corrective actions and involves agency oversight, usually in the form of providing status reports or updated data and information for a period of typically about a year or two while they sort of monitor your progress. If things go really off the rails and you can't negotiate a settlement with the OFCCP, you may find yourselves in litigation in front of an administrative law judge within the Department of Labor, and that could eventually end up in federal district court, and you can appeal all the way to the Supreme Court if you feel like it. But the instances of that is pretty few and far between. Most people are going to settle with the OFCCP and try to move on. So those are the players. That's what we're talking about. The OFCCP, their audit authority. And now let's focus on the focused review, which has really kind of become the new darling of the OFCCP. If you go through and read the OFCCP's regulations, which I only recommend if you suffer from insomnia, it can be very useful there. But otherwise, it can be pretty dry. But if you did, you would see that they have focused reviews in the regulations right now. It's just discretionary whether the OFCCP is going to use them, and they haven't for a number of years. But they decided to revive focused reviews in the last couple of years. And so what's old is new again. And it's been really 10 or 15 years since anybody has had direct experience with these focused reviews. So it's new to most people. They involve a much more intensive investigation in the area of focus. And the idea is that the OFCCP is not going to stray from the four corners of the focus of the review unless something really obvious walks into the room and sits in the middle of it and demands their attention. So it's not out of the realm of possibility that they would that they could be looking at your VEVRAA AAP and discover a huge issue with the hiring of people of color in a certain area of the organization. Just because it's a focused review doesn't mean that the OFCCP can't expand the scope and run those sorts of things down, but it is very, very rare. So the agency is currently, or has been, focusing on Section 503 requirements for individuals with disabilities, and they're right now really ramping up the VEVRAA focused reviews, looking at the requirements for protected veterans. They're eventually going to conduct focused reviews, specifically examining promotion practices, which has my heart rate up a little bit because that will require the OFCCP for the first time, really, to provide a definition of what is a promotion. and I'll be really interested to see what they come up with there. And then perhaps other areas down the road, like, oh, I don't know, maybe a compensation focused review in particular. The good news is, though, I think that if you prepare 503 or VEVRAA AAPs at all, if you just prepare these AAPs in the first instance, your focused review should be a snap, right? Much of the focus in these focused reviews is not necessarily on the technical boxes, because in both contexts, in the 503 AAP and your VEVRAA AAP, there aren't nearly as many technical boxes to check as there are on the women and people of color side of the house. And those technical boxes do not necessarily get us as far as some of the technical boxes in other areas. And so the OFCCP is really focusing on and pushing what needs to be described as best practices rather than requirements. What they're finding is that most of the contractors that they audit in these 503 and VEVRAA focused reviews have those technical boxes checked and nailed down cold, right? Because it's not that hard. And so they want to move the needle. They want to advance the ball. Can I come up with another cliche for that? Probably not. Anyway, they want to go beyond just what the requirements are and really evaluate the depth of the organization's good faith efforts, right? Not just are you compliant, but how compliant are you? How much of a concern is this for the organization? They want to see that kind of commitment, and where they don't want to see it, where they don't see it, they want to provide technical assistance and try to raise the bar. There's another cliche. I found one. All right. So I think you want to be prepared for these things, because an OFCCP focused review, whether it's a 503 review or a VEVRAA review or a future promotion review or something else, is going to be more of a conversation than I think you're used to in a typical OFCCP audit, right? If I get a scheduling letter for a full audit, a full compliance review, or a CMCE, typically my response is going to be to, here's another cliche, circle the wagons in a sort of almost a litigation stance, right? Where we know that the OFCCP is investigating, is looking for violations, and there's an adversarial relationship really from the get-go. It's not unusual to get lawyers involved and to really kind of pore over responses and things like that. Not necessarily a collaborative conversation. In a focused review, though, they're really trying to flip the script. And because they're not focusing so intently on the technical violations, and there really aren't impact ratio analyses and things that they can run on disability and veteran data, they're really looking to have more of a conversation. And that's something that people really need to get used to. And knowing the difference between what is required in the regulations and what is a best practice, so that you know what you might be able to expand on and have a conversation with more freely with the agency, and where you need to be maybe a little bit more guarded. And so for these focused reviews, I think we need to prepare in three main areas, right? There's the desk audit submission. That's the thing that launches everything. That's the initial dump of information and data that the OFCCP is going to use. And we need to button that down. But I think you also need to anticipate and prepare for the inevitable OFCCP follow-up requests. There are some common refrains that we see in OFCCP requests for additional data and information that we see across multiple audits. So we know that these are areas of focus, and we can prepare for those ahead of time. And then also be prepared for and to manage the inevitable on-site, right? For focused reviews, it's the only type of review where an on-site is actually required. It's baked right into the regulations. The OFCCP does not have the option of not doing an on-site for a focused review. Now, in the era of COVID, the on-sites have changed a little bit, and we'll talk about that in a little bit more detail, but it's still a required element of the focused review. And most audit checklists that I've seen only help you prepare for the desk audit submission, right? But there are going to be follow-up requests and questions. The OFCCP, like I said, is interested in the quality of your efforts and the quantity of your efforts. They assume that you're checking the technical boxes, and they are going to come on site. And so usually when I look at an audit checklist, it's just a restatement of the scheduling letter. I'm not sure how helpful that is really. I think we can prepare a little bit better for that by understanding not only what the OFCCP is asking for, they've already told us that in the scheduling letter, but how are they going to use it? Why are they asking for it? What are they looking for in the materials that you submit to them? And we'll talk about that right now. The desk audit submission really is, it's all about understanding what they're asking for, why, and what they actually want, because those things aren't always the same. What they ask for and what they really want, sometimes there's a little bit of disconnect. So when preparing the desk audit submission, it's more than just copying documents, right? By the way, we don't get the automatic 30-day extension option that we get with full audits, where you can submit basically half of the desk audit submission and get an automatic 30-day extension. But again, in the era of COVID, the agency is being very flexible should you need additional time because of the pandemic and things like that. But the focused review scheduling letter asks for 12 things up front. And the first thing they want is a copy of your current AAP under the Executive Order 11246 for women and people of color, which is sort of odd to be the first thing that they ask for in a VEVRAA focused review. They're asking for your women and people of color AAP. Why? Well, the only thing that they're really looking for there is the job group analysis. Maybe the workforce analysis to get a sense of how the company is actually organized. But the job group analysis is really what they're looking for, because that's not a component of the VEVRAA AAP. The assumption is that your veteran and your disability AAPs use the same job group structure as your AAP for women and people of color. And so that's what the OFCCP is looking for there. Why they don't just request the job group analysis is beyond me, but they want the entire narrative and the supporting documents and analyses, like the job group analysis, workforce analysis, comparison of incumbency to availability, and goal setting. But the only thing that they should really be focusing on and asking follow-up questions about will be that job group analysis. The second thing they ask for is your AAP for protected veterans. This is obviously the focus of the review. That AAP is going to be the narrative and your veteran hiring benchmark and how it was set. And they want the results of the evaluation of the effectiveness of prior year outreach and recruiting efforts for individuals with disabilities or veterans, depending on the focus of the review. Here it would be veterans. This should be part of your AAP, but the evaluation itself, usually a lot of organizations don't include a lot of detail about the evaluation in the AAP document, because if an applicant or an employee asks to see it, we have to turn it over for them to view. And we're not required to put all of the company's kind of thinking and deliberations into that document. So there may be a separate document that you may want to go ahead and meld for the purposes of the desk audit submission, right? This includes any base efforts, because unlike for women and people of color, where you're only engaging in additional targeted outreach and recruiting if and when there is a goal to address, here for individuals with disabilities and for veterans, there's a requirement to engage in some base level of outreach just as a matter of course. The only question to be determined by either the disability utilization analysis or the veteran hiring benchmark is, do we need to do anything above and beyond our base efforts? And if so, the OFCCP is going to expect to see some evaluation of whether or not we think those efforts are effective and worth continuing. They also ask for the data metrics, technically called the data collection analysis. That's the total job openings, the total jobs filled, total applicants, and the number of those that are disabled and veteran, and the number of those that are disabled and veteran hires. Not particularly useful as a metric, and I very rarely get follow-up questions about it. So that's a standard part of your AAP preparation process, and you shouldn't be focusing on it too much, other than making sure that your numbers line up. They also want document evidence that the internal and audit reporting requirement was met. This request was sort of dropped in the revised scheduling letter and has now become a follow-up request. So I need to update these slides. But typically the OFCCP wants to know that this is more than a paperwork exercise where we prepare an AAP, we print it out, we put it in a binder, we put it on a shelf, and we never look at it again until next year when it's time to refresh it. So they want to know that we're reporting out to people that need to know what they need to know from the AAPs, like the hiring managers, like the recruiters, and the executives that hold the purse strings and control the resources and things like that. So typically they want to see calendar and meeting invites and attendee rosters and presentation materials and things like that. It's not technically required that be a part of your record keeping, but the OFCCP knows that we live in an era of applications like Outlook and things like that, where there's going to be some sort of, instead of paper trail, a vapor trail in the data and the ether that we can pull out and prove that, no, we are talking to people within the organization about the results of our AAPs. And they also want documentation of the veteran hiring benchmark. Now, if you set your own veteran hiring benchmark by using the 5-factor analysis, then you need to show your receipts. I have yet to find any organization, though, that is setting their own veteran hiring benchmark. Every organization I work with is simply adopting the national percentage of veterans in the civilian labor force at the start of the current AAP cycle. And so there's not a lot of documentation to turn over here. That's going to be a pretty pro forma thing. They also want copies of your collective bargaining agreements if you have collective bargaining agreements, right? If you're a unionized environment here, they're mainly interested in just the formal lines of progression and pay schedules, because they're going to look at veteran promotion rates and for differences in compensation based on veteran status. And they need to know where a collective bargaining agreement controls and where it doesn't. So that if they have issues, if they have questions, they need to know, is this a union issue? In which case they have to consider whether or not they want to get a union involved, or is this a company issue? So that's the main thing that they're looking for there. If you're, like a railroad or something that literally has collective bargaining agreements going back 200 years that if printed out would fill a train car, then you can probably get away with providing certain sections of CBAs. Just work that out with the compliance officer in advance. They also want copies of your reasonable accommodation policies and documentation of requests for accommodations and their resolution. You're not actually required to have a formal written policy or keep documentations of requests. But if you do, and you have those things, you have to turn it over. I also like to encourage people to consider taking credit for informal accommodations, right? It used to be that if I wanted an ergonomic keyboard or a mouse pad with a wrist support or lumbar support for my chair, there was a formal process I had to go through to request those things, and they would be ordered. Fast forward to today, and a lot of those things are provided as a matter of course. And so if we don't have a lot of requests for accommodations, we don't have a lot of things to flesh out here, consider, though, taking a look around the workplace and taking credit for the accommodations that have happened, even though we don't really think of them that way, and we didn't call them accommodations, and maybe they didn't go through a formal process, but nonetheless, people with different abilities are being supported. And we want to show the OFCCP that that's just a part of the culture today. And that can go a long way, because in a focused review, that's really what OFCCP is looking for. How much of this is ingrained in the culture, and how much is, for lack of a better term, maybe resistant within the organization. They also ask for applicant and employee level self-ID data. The OFCCP asks for names associated with self-ID data, but in every instance that I've been involved in, employee ID suffices initially, unless and until they identify specific people that they want to talk to for a specific reason. So even though the scheduling letter says to send in and include name, in every instance that I've been involved in, substituting and only providing employee ID and protecting some of the confidentiality there has been acceptable. And basically, we just simply include applicant self-ID data in your response to item 11 below, which we are coming up on at the bottom of this slide. But before we get there, we're going to also have to provide an assessment of our personnel processes, including the date of the last assessment, the results of that assessment, and the date of the next scheduled assessment. What an assessment of personnel processes is not very well defined. So you have a lot of wiggle room there, a lot of elbow room to define what that means. But the OFCCP has been very clear, this is not an annual requirement, but it's required to be done, whatever it is, on a quote unquote scheduled basis. And so they believe that there should be a date for the last assessment and a date for the next scheduled assessment. All I can say is if you haven't scheduled the next assessment yet, now would be a good time to do so if you're responding to an OFCCP audit scheduling letter, and keep in mind that that date is not necessarily set in stone. So if you need to move that date later, you can. The OFCCP just needs to see a date. All right. They also want your most recent assessment of physical and mental qualifications. Primarily, here they just want to know that it's happening, that somebody is taking a look at the physical and mental qualifications and making sure that to the extent that any of those qualifications might get in the way of an otherwise qualified individual with a disability, or here a disabled veteran, that it is business necessity and job related. So they want to know that people are looking at that, and they want to know if any changes were made as a result of those looks, right? So it may very well be that we're doing the looking, but we haven't had to make any changes, and that's acceptable for you to say. If you have, take credit for it, right? I was in, the other day, I was in the hardware store that I used to manage the plumbing department of, and it used to be a requirement that you had to push and pull a full pallet of, things like concrete blocks and things like that. Well, now they have motorized pallet jacks, and that's no longer a physical requirement. And so they've pulled that out of their job listing, as they should. If those sorts of things are happening, you want to find a way to capture that and reflect that back to the OFCCP to let them know you're engaging in good faith and making a difference. And finally, the applicant employee level activity data, the applicants, hires, promotions, and terminations. Yeah, the OFCCP has decided that they want to take a look at that, despite the fact that when they revised these regulations back in 2014, they swore up, down, sideways, and diagonally, in private, in public, and officially in the Federal Register, that the agency would not do any statistical analyses of disability or veteran hiring. And they are reneging on that promise. So they are going to perform statistical analyses of veteran hiring, veteran promotions to the extent that they can, and veteran terminations. That information is reliant on self-identification data that may or may not be particularly reliable. And so far, the agency has only really used the results of those analyses to drive a conversation about the culture and best practices. I have yet to see them use the results of those impact ratio analyses in either a disability or a veteran-focused review as the basis for a violation and a discrimination charge. I don't think that that's where the agency is headed, but they do want to get a look at the numbers to try to get a sense of, how much or how little disability and veteran initiatives are really part of the company's culture. And they think that the more it's ingrained in the culture, the more that will be reflected in the numbers. And that may be a valid assumption. But again, they're so far, and I don't think this is going to change, they're not trying to rack up discrimination violations and conciliation agreements from this, but we'll keep a close eye on that. And finally, the one that gets most people's hearts racing is they want employee level compensation data, right? They want to perform regression analyses accounting for time with company and any other explanatory variables that you choose to provide. And here they'll be looking for, is there any sort of pattern that they can discern where veterans are being paid less as a group in either overall or in certain areas of the organization. I have yet to hear of any instance of that actually being an issue within any organization. It's just not as common as people unconsciously or subconsciously offering to pay women less, for instance, as opposed to, oh, good, you're a veteran, we can get away with paying you less. It just hasn't been as ingrained in our society and our history. And so my experience so far is that the OFCCP is not finding a whole lot there, but they are taking a look. And so that is the desk audit submission. It's a lot of stuff. Some of it is just make a copy of the document. Some of it we're going to want to take a look at, right? Before we hand over compensation data, we're going to want to try to take a look and see what the OFCCP is going to see so that we can prepare for the inevitable follow-up, right? Nothing demonstrates a strong compliance posture than ready answers. And the flip side of that coin is nothing demonstrates a weak compliance posture than responding to every question from the OFCCP with, well, I'm going to need to look into that, and I'm going to need a couple of weeks. Again, in a focused review, the OFCCP is trying to engage in a conversation. They want this to be a back and forth. And the more we can meet them on that playing field and in that conversation, the stronger our compliance posture is going to be, and the smoother the audit is going to go. So based on OFCCP guidance, their public statements and reports from the field, we know that there are certain things that the OFCCP is likely to follow up on in every VEVRAA focused review. Is the organization aware of its non-discrimination obligations regarding military spouses, family, and other affiliated persons? This has cropped up fairly recently, although it's been in the regulations forever, that the regulations do not just prohibit discrimination against the veteran, but also there's basically a friends and family plan. People who are friends, family, business associates, or otherwise associated with military personnel, we can't discriminate against them based on their affiliation with a veteran. So yes, we know hopefully we know that that's part of the law, but does the company policy actually reflect that? In my experience, most of them don't. Most of the policies that mention veteran discrimination hew pretty closely to other areas of the regulations, and most don't capture this. But that doesn't mean that you can't. That doesn't mean that we can't add a line to our policy to reflect our understanding here and submit that to the OFCCP. If they ask, was that policy recently updated? Well, we'll want to be transparent and say, yeah, we updated it right before we sent it to you. But in my experience, the OFCCP generally doesn't ask. They just want to see a robust policy and know that that's the policy on a going forward basis. Another common question that we get are, do you train your hiring managers regarding the company's veteran equal employment opportunity and affirmative action obligations? This is oddly the only explicit training requirement in all of the OFCCP's regulations, is training hiring managers regarding EEO and AA obligations for veterans and individuals with disabilities. There is no other training requirement today in the OFCCP's requirements. We refer to it internally as the 44J training, and the OFCCP has started to ask about it. They want to know that the training is actually going on. They're starting to get kind of curious about the content of that training, and so we're finding that the OFCCP is diving a little deeper in there. And what we're finding is that because the OFCCP has not really previously enforced subparagraph 44J, a lot of people are being caught off guard by this. So if you're not including veteran and disability EEO and AA obligations in your training of hiring managers, now would be a really good time to start. Make sure that that training includes references to military spouses and children and affiliated people. And one that I've been trying to push, because it's actually the more common form of veteran discrimination that I see, is what I refer to as veteran on veteran discrimination. We don't talk about it very often, but in my experience, it happens quite a bit, where I've got let's say a hiring manager who is also a Marine, and that Marine has some feelings about people who served in maybe other branches of the the armed forces or in other capacities. And that can come out in biases in hiring and promotion and even compensation. That can be sort of a hidden thing. That's not necessarily something that's on the OFCCP's radar. So what I have found is that including discussions about veteran on veteran discrimination in our hiring manager training can go a long way to demonstrating to the OFCCP that not only are we engaged, but we are seriously engaged in good faith. We're thinking these things through and adding things that maybe best practices aren't technically required, but again, really kind of bolster that compliance posture. They're very interested in what veteran resources you leverage in a variety of ways, right? Affinity or employee relations groups. Are you aware of the U.S. Department of Veterans Affairs and the offerings and things that they provide? Local veterans employment representatives, basically the state job board. Are you just having your career page scraped and your listings sent out to the state job board, or are you making any sort of one-on-one, person-to-person connection? The more person-to-person connections you can show, the happier the OFCCP is. Veteran representatives at colleges or technical schools, personnel on military bases involved in transition of military personnel to the private sector. They want to see the organization making these kinds of connections and strengthening their veteran pipelines. And then internal resources to help the company better understand and support the veterans that they bring in, being able to translate military occupational specialties into the relevant work experience and job qualifications, veteran buddy systems for transitioning veterans and mentorships and things like that, and anything else you can think of. Expect the OFCCP to ask into these areas, and the more you have to throw at them and the faster you can turn that around, the better your compliance posture looks. They're also almost always asking about medical examinations or questions administered to applicants or employees. This applies to both Section 503 and VEVRAA because of the disabled veteran category. Here, if you're compliant with the ADA, and I think most, if not all of you are, you should be fine here because your ADA processes and policies and procedures have been very carefully crafted over the last 3 decades and are more than sufficient to satisfy the OFCCP. But they are interested specifically in policies and procedures for handling medical information. They don't actually enforce HIPAA, but there is a record-keeping requirement that medical information be kept separately from the regular quote-unquote personnel file, if anybody still uses that terminology. In other words, medical information needs to be in a separate confidential medical file. So to the extent that your company actually has and keeps medical information on employees, you'll want to be able to verify to the OFCCP that those processes are in place. That shouldn't be much of an issue. Your job application accommodation process, however, my question is, have you tested it lately? And would you like to guess who will? What I find very commonly in not only focused reviews, but pretty much every review that the OFCCP is doing these days, is that as part of the review, they'll just go out and apply for a job. Not because they want to work for you, but because they're testing the application process. They're seeing when the self-identification forms are presented. Are those self-identification forms compliant? And very often, they'll get the idea of, well, let me get about halfway through this process, stop and request an accommodation and see what happens. You want to know before they do that, that everything there is working well, that somebody is going to respond to those accommodation requests, and that the accommodation request and provision of that accommodation itself is not going to prevent somebody from being able to file a timely application. All right, which kind of brings us to website accessibility. You're not actually required to be what we call Section 508 compliant, meaning fully compatible with assistive technologies like screen readers and alternate input devices and things like that. You're only required to provide accommodations for people who need one to complete the application process. However, the OFCCP has a valid concern here. Is this organization concerned about their websites being accessible to people with disabilities, including disabled veterans? Even though it's not required, They want to see a level of curiosity there. So at the very least, running an assessment and knowing the state of things might be a good idea, even if that assessment comes back and says, wow, you're really not anywhere near being compatible with assistive technologies. That's okay, because that's not a violation of the OFCCP's regulations. So that's one area where you can feel safe talking to the compliance officer and being fairly open. We've run an assessment. We've identified some shortcomings, and we're going to look toward, moving toward addressing those and doing a better job. I understand that that's not actually a requirement, but it's something that we're very concerned with and that we want to do better about. Have that conversation. It's perfectly safe, because no matter how bad your website is, it's not a violation of the OFCCP's regulations. But being prepared to have that conversation, showing them that you're concerned, and God forbid, actually doing something about it, can really, again, strengthen your compliance posture. And so the more prepared we are for these follow-up requests, common follow-up requests, in addition to any issues that we may spot in the materials that we're turning over as part of the desk audit submission, the smoother this is going to go. We want to impress the compliance officer with just how seriously we take these things, and how much we're trying to make it a part of the organization's culture. Which brings us to the unavoidable onsite, right? They're coming to your house. So kind of like when my mother-in-law wants to visit, I'm gonna go vacuum the rug and straighten things up. And we wanna do the same thing before we let a federal law enforcement agent inside our house. First, work with the OFCCP to schedule the onsite. They like to try to dictate the schedule and just inform you that we will be conducting an onsite next Wednesday. They don't really have the authority to dictate that. They're supposed to work with you and negotiate times and locations and all of the logistical details that work for both parties. So don't let them bully you. Gently push back and let them know, I appreciate that that's when you want to come, but here's what works best for us. Let's see where we can meet in the middle. Back in the olden days, the before times, before the pandemic hit, we would want to reserve workspace for the OFCCP and our team. As soon as we come out the other end of this, we're going to need to do that again, right? Where we want separate OFCCP workspace for interviews and for reviewing documents if you can, so that they're not potentially inadvertently leaving documents and other confidential information around while they're interviewing employees and managers and things like that. So if we can just provide them separate space, that can go a long way to addressing those concerns. And then you want to set up your own war room nearby, if you can, where you have ready access to documents and things that the OFCCP might be asking for, and can strategize and be available. And usually if the OFCCP is actually physically coming on site, I want to designate OFCCP escorts, right? If it's, sometimes it's just one compliance officer, sometimes it's a team of 5. Regardless, I don't have to let them wander around my facility unsupervised. This can get a little bit contentious. The OFCCP doesn't really like to be followed to the restroom, but nonetheless, just because they have the authority to come on site does not mean that that we have to leave them unsupervised. And I like to know what's going on. So we want to have OFCCP escorts. We always, in the virtual area, we always want to have someone on the call or on the video conference meeting to the extent that we can. And if they are coming on site, there are some people in this world who still smoke cigarettes. I know that may be difficult to comprehend, but it's true. And some of them work for the federal government. You cannot believe how much smoother things go if the compliance officer knows that they can take a smoke break if they need to. Sometimes that may require accommodating them and bending our non-smoking policies and providing an area where they can go, escorted, of course. I don't want them going out to the smoking area and just shooting the breeze with the other people out there without somebody representing the company's interests there. But a happy compliance officer is, well, a happy compliance officer, and happy compliance officers tend to close audits. Really what I need to do though is I need to prepare my managers and supervisors who have been selected for interview. And in the era of COVID, that's very often either going to be a telephone interview or a video conference. They represent the company. And so what they say and do is effectively the company's actions and words. So we get to prep them more extensively. We need to make sure that they know that there is an affirmative action program for protected veterans, and what it entails and what their responsibilities are. Having a hiring manager or supervisor in an interview respond to the OFCCP with what AAP is just not something they should say. And we want to be prepared for what are called bifurcated interviews. Sometimes the OFCCP wants to interview the manager in their capacity as a manager, at which point they are a representative of the company, and the company can have a representation in the room. We can have one of our people or a lawyer in the room for that portion of the interview. But sometimes they want to also interview that manager about their experience as an employee, at which point the company is not automatically allowed to have a representative in the room. And so very often we require the OFCCP compliance officer to conduct those interviews in 2 stages. And we need to be prepared for that and to prepare our managers to know that once the company representative has been kicked out of the room, if the conversation circles back to the policies and procedures that they follow as a manager, that they need to stop the interview, open the door, and invite the company representative back in. Not that I want to assume that there's going to be those sorts of shenanigans, but they do happen. So we want to prepare our managers for that. We also want to prepare our employees. Now, our employees, we can't prep them like we do our managers, but we can inform them of their rights, let them know what's going on, why they're being asked to talk to a federal regulator, let them know that they're not actually required to do so. They have the right to decline. They have the right to have their own representative in the room, and let them know that they have the company's support, that what they do and say in that interview is going to be kept confidential. It's entirely up to them what they choose to share or not. And if anyone pressures them, that they have the support of the company. We'll make that end immediately. So we want to prepare our managers and supervisors and our employees that are going to be interviewed before the OFCCP interviews them. And if they're coming on site physically, we want to inspect the place. In a virtual on-site, they're usually asking for either still pictures or a video walkthrough. And so not that I would suggest that you stage those photos, but nothing says you can't clean up the place before you snap the picture. So inspect the place. The OFCCP is usually interested in things like accessible stalls in the restrooms. Are there ramps and handrails? Are the handrails secure? Are the doorways and walkways wide enough? And are there accessible parking spaces? Is there any graffiti or inappropriate decoration in people's cubicles and things like that? Those are the types of things that OFCCP is looking for, again, to see, is this place a culture of inclusion for veterans and people with disabilities and others? That's really what they're looking for, and that's what we want to be able to showcase for the on-site, whether physical, in person, or virtual. And then I recommend that we review any veteran or disability-related complaints from the past year or so, right? If there haven't been any complaints, that may be something that we want to be able to show the OFCCP to indicate, well, how well we're doing. We have this process in place where people can raise their hand and say, I think there's an issue here. And if we don't have any records of those complaints, we should say so. If there are some complaints, we want to make sure that they're resolved or are on their way to resolution, and consider following up with the complainant to make sure all is well, because the OFCCP may very well want to interview them and ask them about that process and their experience and things like that. And we can also use the complaint information to issue spot things that we haven't thought of. So the focus is on compliance, yes, but how well you comply is really the focus. How involved and how in good faith your efforts really are. And so we want to be prepared, and I think we want to find and use the right resources, which I humbly submit are mine. BCGI happens to have a VEVRAA Focused Review checklist. I don't think it's your ordinary checklist. It comes in kind of 4 parts. The first part helps you track things like due dates and responsible parties. The second part helps you prepare the desk audit submission and does a lot of what we did today. For every single item that you're being asked for, it's going to explain what that is, why the OFCCP is asking for it, and how they're going to evaluate it, with links to additional resources to help you really button those things down. Then a third section is going to help you prepare for these common follow-up requests and inquiries. And the last is going to help for you not only prepare for, but actually manage the on-site visit or the virtual on-site. So the idea is that we've got one document that can basically be used as a project management document. And from soup to nuts, beginning to end, from the date that the scheduling letter is received to the time that we close this audit with a letter of closure and no violations, that you have a tool that you can use to keep things organized and be on your toes, be able to respond back to the OFCCP quickly and confidently, showcasing just how robust your affirmative action program is, how there is no there here, and how we really need to close the audit and move on. That's the idea. Make your own if you don't want to use mine. Everyone who is attending today's webinar will have access to the BCGI VEVRAA Focused Review checklist in Microsoft Word format. If you need it in a different format, you can contact me and let me know. We're here to help. Final thoughts, sit up straight, right? Our compliance posture matters again. If you've been in this space for any length of time, and if you experienced the Obama administration and particularly Patricia Hsu as the OFCCP director, you went through a time when your compliance posture was not so important to the agency. You could have all of the good faith efforts in the world, all of the best practices implemented, but if they could find one little thing wrong, they were going to nail you to the wall for it. And I think that was unfortunate. I don't think that was a very effective way to motivate contractors into going beyond compliance. And this administration, and particularly under Director Craig Lean, has really flipped the script, brought the OFCCP back in line with the law and the regulations, and is focusing on what's important. Yes, checking the technical boxes are important because that's what gets you to the starting line, but what happens after the starting gun is fired? How well you run the race is important again. And now it's a little bit different. If we fall down a little bit on this or that technical requirement, but otherwise our compliance posture is strong, that can go a long way. And so the degree of compliance is measured by your effort again, not necessarily the results, which is the way it should be, right? If we measure it by the results, we encourage people to take shortcuts or maybe break the law to make the numbers. It should be measured by the effort. That's more difficult to do. And so this administration and this agency has taken that on, and I think have been doing a pretty good job. So we need to get back into the habit of highlighting our compliance stance, our strong compliance posture, because it matters again. And don't be afraid to engage with the OFCCP. We've been trained. It has been beaten into us over the years that this is a litigation-like adversarial relationship. And in some cases, that is true. But in the focused review context, most of the discussion is going to be around best practices that are not requirements. And so it's okay to have some back and forth, to admit to some shortcomings, to admit that certain things may be a work in progress. You need to know the difference between a requirement and a best practice. But when you're in the best practice realm, you can speak more freely with the compliance officer. And the more guarded you are and the more of a litigation stance you take, the harder these focused reviews are going to be, the longer they're going to drag on. The more you engage with the OFCCP, in my experience so far, the smoother these things go and the faster they close. So be polite, but be on guard for violations that aren't violations. Once in a while, the OFCCP may try to characterize it as, well, your website is not compliant because it's not compatible with adaptive or assistive technologies. Well, no, it's not, but that's not a violation. So we can talk about that. I'm happy to talk to you about that, but that doesn't go into a notice of violation of any sort. And as long as we're clear on that, we can have a conversation. Be polite about it, and I think that'll get you pretty far. If you're preparing the AAPs though, the technical boxes are going to be checked. It's all about what are you doing after the AAPs? Is this just put on the shelf? Or is this a living document? Is this something that somebody in the organization is asking questions about and trying to move the needle? And if so, that's what the OFCCP wants to see, and that's what we want to be able to show them. And we can do that if we prepare right. So I've been talking for quite a while. If you have questions and comments or just general heckling, this is how you can get a hold of me. But I'm going to stop here and see if we have any questions that have come in through the Q&A.
We do have some questions, Matt, that have come in. I'm going to get to a couple of them, and then for the rest of you who have to fall off at some point, we will follow up with written answers via email. And so let's just jump right into a couple that we had. Does it help to, with the VEVRAA audit, to have a military skills translator built into your career page? Is that something you could point to?
Yes, that is absolutely something you should take credit for and is awesome. That's one of the things that can really help smooth the transition on both ends, right? For the veteran coming in and the people receiving new veteran hires to have a better understanding of what their background is and how it meshes up with the company's needs. And for the veteran to understand how their experience in the military is going to contribute to their new role is absolutely something that's not required, but if you have it, definitely highlight it.
Okay, we had a similar question around, does having a disability equality index rating assist in audits?
It can. I've found in my experience, at least so far, that compliance officers are not as familiar with that, and it doesn't tend to carry quite as much weight. And they're a little bit skeptical of anybody else's assessment of just how good you are, other than their own. So I'm not sure I would classify it as a particularly high value item, but yeah, if you have a good rating, throw that in the mix.
Fantastic. And just one more, and then we'll get to the rest via email. Just to recap, how often are VEVRAA audits scheduled? Are they typically random or only done when a complaint is filed?
I have yet to see one from the result of a complaint, but the OFCCP usually about twice a year will publish the corporate scheduling announcement list, the CSAL list of organizations that were selected but not yet scheduled for audit. They basically give you a heads up. And the last audit list that they did was exclusively for VEVRAA Focused Reviews, and there are about 500 of them. If I recall correctly. And so they're starting to make their way through that list now. And I expect that we'll see the majority of new audits for the foreseeable, probably for the remainder of the year, will be VEVRAA focused reviews.
Right, so now is the time to start getting ready and start preparing all of the documentation. Excellent. Well, Matt, thank you. I'll stop there, and I'm going to ask you to advance to that last slide. Thank you all for joining us today. Thanks to Biddle for this wonderful presentation. If you'd like to join us for an upcoming CIRCA webinar, feel free to jump on the website. You can find a listing of events there at circaworks.com. You can also take a look at all of their products and services. We'd like to thank all of you for coming, and we hope that you will join us again on another CIRCA webinar in the future. Thank you very much, and have a great rest of your day.
Thanks, everybody.